My husband injured his back at his previous job. He has continued to have issues from it. They sent him to some specialist, and they put something in his back, but he's still continuing to have issues. Can he go back and reopen that case, even if he's not working for that company?
Hi, Lisa. That's a good question, and the answer is yes. Even if your husband does not work for that employer, if he has an open work comp claim with that employer, then he should contact the former employer or the work comp carrier, and they'll schedule an appointment for him with the authorized doctor.
David, talk to us a little bit about, if you're hurt on the job, the significance of reporting that injury to your employer, and a little bit about the statute of limitations and how that works with workers' compensation claims.
Sure thing. So after someone gets hurt at work, the first thing they need to do is notify their employer that they have been injured on the job, and then ask to see the company doctor or the work comp doctor. The employer is responsible, the employee is responsible for telling their employer that they were injured. They have to do that within 5 days. 5 days, it's called 5 days of verbal notice. The injured worker also has 90 days to do that in writing, but it's best to go ahead and do it as quickly as possible and ask to see the company doctor. And the second part you were talking about, Kirby, the statute of limitations. And what that means is the injured worker has 2 years from the date of their accident to settle their claim or file it in a court of law to preserve their rights. And that 2-year window is also extended if the injured worker is paid temporary total disability benefits or temporary partial disability benefits. So if they get paid what's called TTD benefits, then the 2-year window is extended out based on the last payment or last compensation paid to the injured worker.
And David, would you recommend that if someone is injured on the job that they begin to document that in writing just on their own from the very beginning, just to take their own good notes?
I think that's a good idea, absolutely. It's important because the injured worker may go to dozens of medical appointments, dozens of therapy appointments, and you might treat for a year or 2 years or 3 years, and it's hard to remember that far back. So keeping notes is a good idea.
And David, what about retaliation? Let's say I'm injured on the job and I'm concerned about my boss getting mad at me or my company firing me. How does the law deal with that?
Yeah. So in Alabama, it's illegal for the employer to fire an injured worker for making a workers' compensation claim. So it's a no-no. But it does happen. It is illegal for the employer to fire someone for making a claim, and so that is something that we advise clients about and can help them with that as well, because it might not be just a work comp claim, Kirby. It could be a retaliation claim as well.
And David, for the business owners out there that may be watching tonight, or supervisors, there can be some really stiff penalties for the company in terms of damages that a jury may award in that circumstance. Is that not correct?
That's a real good point. Yes. So a workers' compensation claim, if you go to trial, you're hearing just the judge is going to hear that. But if you have a retaliatory discharge case, then a jury can decide the damages. And in those type cases, you're talking about compensatory damages and punitive damage as well, which is different than a workers' compensation case where the injured worker is limited in their recovery.